Hello, everyone, and welcome to this evening's session. Tonight, we will be discussing the continuing impact of the 1999 Constitution on the Cherokee Nation. Tonight's presenter is Dr. Julia Coates. I'm your moderator, Kimberly Gilliland. We'd like to thank all of the PENS Project volunteers that have graciously agreed to participate this evening, and Star University's Department of Tribal Governance and Administration. This fall, Star University will partner with the Cherokee PENS Project to offer a certificate in Cherokee Government and Society, as well as Cherokee Language Certificate programs. For more information, please contact STAR at info@staruniversity.org or visit the website at staruniversity.org. At this time, I'd like to introduce Dr. Julia Coates. Julia is a citizen of the Cherokee Nation, born in Pryor, Oklahoma, and raised in Northern California. She holds BAs in Anthropology and English from San Francisco State University and a PhD in American Studies from the University of New Mexico. Dr. Coates was a delegate to the Cherokee Nation Constitutional Convention, was the project director for the award-winning Cherokee Nation History course, and served 2 terms on the Cherokee Nation Tribal Council. Welcome, Dr. Coates.
Okay. Thank you very much for having me with you tonight. Hang on, I'm still fiddling with my computer. There we go. Okay. This is the last in the series of 4 of these conferences on the Cherokee Nation Constitution. And I really hope that those of you who have been able to participate in all 4 of them have enjoyed this series. I started out the first one on my own, and then we've had guests on the second and third one. And so I'll be wrapping it up on my own tonight as well. We want to just sort of bring us up to the current moment in talking about the 1999 Constitution, because we left off with Jay Hanna last time, talking about a constitutional convention, which I think is probably one of the more amazing events of our lifetime. And for those of us who were able to participate in it, there will just never be anything quite like it, I think, in terms of the wonder, if you will, of watching Cherokee people, many of whom were sitting on opposite sides of the political fence at that point in a very, very heated moment. But watching people really come together to think about the greater good and good governance and how to go forward in the future. So we came out of that, I think, with a rather amazing document. And that's where I want to begin tonight. What happened after that? Because there were some real ironies that have taken place. There have been some dirty tricks that have happened. And there have been some other things that relate to this Constitution that we probably need to think about going forward. So I'll start out with the 1975 Constitution, the document that existed before we revised everything in 1999. And in the 1975 document, you may recall from the very first webinar, there's a little article in there, I think it was Article 10, that said that any revisions to this Constitution or any new constitutions, any amendments, must be approved by the Bureau of Indian Affairs before they can go into effect. Now, this is a requirement, this restriction, that is often placed on tribes that are organized under federal statutes, a federal statute called the Indian Reorganization Act, or for those tribes in Oklahoma, there's one that's called the Oklahoma Indian Welfare Act. And so for tribes that have organized themselves politically, governmentally under those federal statutes, this restriction exists for them. Indeed, any new constitution, any change to their constitution, their bylaws, whatever they call their governing document, has to be approved by the Secretary of the Interior, the Bureau of Indian Affairs. And so in 1975, even though we had never organized under those statutes, we were told the same thing, that we would have to have this in our Constitution. And because it was such I would say a weakened moment when the understanding of sovereignty was not as well developed as it is today, because frankly it had been destroyed through much of the 20th century. We acquiesced to that. We agreed. We said, okay, if that's what we have to do, you know, in order to sort of get ourselves kick-started again as a government, then that's what we'll do. So when we did a very extensive overhaul of that document in 1999, the thing we had to do was to take that document to the Bureau of Indian Affairs, to the Secretary of the Interior, and to put it in front of them and say, will you approve this? Can we go ahead and enact this document? Now, when we did that, actually, before we did that, we started sending it out to area offices of the Bureau of Indian Affairs, and we did this because we wanted to put it in front of attorneys. And the question that we were asking as a government was, is there anything in this document that you see that will not stand up to legal muster? That the attorneys, the solicitors as they're called in the various area offices of the Bureau, they started tinkering with the document. They were kind of like, well, we don't really like this, and we don't really like that. And at some point, Chief Smith just kind of pulled it back, and he said, that's not what we asked you. We didn't ask you if you liked it. We asked you if it would stand up to legal challenge, right? And so when these attorneys started sort of nickel and diming it, we just took it back and we said, forget it. You know, we had enough attorneys as part of that convention. We thought that we were on pretty firm footing. So at that moment, we just went ahead and asked for approval, sought approval from the Secretary of the Interior. Now, at that time, the Secretary of the Interior was a man named Kevin Gover, and we kind of chased him around for a bit, and he kind of made some noises like, yeah, he'd be favorable to doing this, but never, you know, could just never get it in writing from him. And so after several years of just sort of trying to chase down this approval, we came up with something else, the leadership, the administration of the Cherokee Nation. And they approached the Secretary and they said, would you, instead of approving the entire Constitution, would you approve just one amendment? And that is the amendment to strike Article 10 from the 1975 document. Would you sign off on removing yourself from the oversight process? And we got an indication that, yeah, if it was just one amendment like that, to take themselves out of it, they might go ahead and do that. So in 2003, which was a regular election year for us, we were electing the principal chief and the council and so forth that year. You may recall, those of you who voted, that there was an additional question on the ballot in, I think it was in June, because we kind of knew there was going to be a runoff in the chief's race in particular. So we put one question on the ballot in June, and that question was to approve just one amendment to get the Bureau of Indian Affairs out of our constitutional revision process. And in June of that year, the Cherokee voters approved that one amendment. And once they did that, then we went ahead and put the entire document, the entire revised Constitution from 1999 in front of them and said, would you vote on this and approve this as well? And that question, I think, was on the ballot of the runoff in July, about a month later. And they approved it as well. So with this, we had one amendment that we could take to the Secretary of the Interior, get their approval on that. And once they approved that, then we were lined up and ready to go. We already had approval from the voters to begin implementing the 1999 Constitution. But when we took the one amendment to the Bureau of Indian Affairs, they hemmed and hawed again. They just dilly-dallied around. Again, it was like, yeah, we'll approve it, but we could never catch them in the hallway. We could never really pin them down. So this went on for a couple more years. And finally, the Secretary of the Interior that was appointed under the Bush administration was a Chickasaw man. His name was Neil McCaleb. And we finally got something in writing from Neil McCaleb. It wasn't approval, but it was a letter that was stating that he intended to approve it, that he intended to approve our one amendment. And so we received that, I think, in December of 2006, I believe, of 2005, if I'm remembering correctly. But then something, and I don't recall what it was, happened, and McCaleb, President Bush offended him in some way. And so McCaleb resigned from the position, and we just went, we still do not have the approval in hand. And now what are we going to do? And so now we enter into a period of time where they're just interim people who are not, until there's another confirmed appointment, they're not going to go out on the limb and approve, et cetera, et cetera. So finally, by the summer of 2006, the question that the chief was asking was, can we just take this in front of the court, take this letter of intent in front of the court and see if maybe our own tribal court will give us the go-ahead to begin implementing our Constitution just on the basis of this letter of intent that the Secretary of the Interior stated that he intended to approve. And so that was the question that came to the court in mid-year in 2006. And our highest court, which was called the Judicial Appeals Tribunal, approved it at that time. They said, yes, the letter of intent from the Secretary of Interior is good enough. Go ahead and begin implementing the provisions of the 1999 Constitution. Now that was a 2-to-1 decision. There was one justice, and she happened to be the Chief Justice at that time, who dissented from the other two. And her name was Stacey Leeds, and she is a professor of law now at the University of Arkansas, and she was the dean at the law school there, the first Native American dean of a law school in the country. And Professor Leeds, I had invited her to, on a couple occasions, I've invited her to come in and speak to my classes via Skype. And we asked her about this episode, this era, right, and the rationale for her dissent. And she was very, very gracious in explaining to us that she said, well, she didn't disagree. She wanted to go ahead and implement the Constitution. She wanted the Bureau out of the approval process. She knew that this was a way to strengthen our sovereignty, and she wanted nothing more than for our nation to strengthen our sovereignty to its fullest. But in the end, her sense about things was the law was the law. And a letter of intent is not an approval, and she just, by the letter of the law, she just could not get past that. So certainly, that's the perspective the dissent took in this situation. But the other two justices went ahead and said, yes, let's go ahead and implement this thing. So in 2006, that's what we started to do. And we were in the phrase that we hear so often nowadays, we were in uncharted waters. We didn't know what would happen. We didn't know what the response would be on the part of the Bureau. And as the months went by and there was basically no response, and then that turned into years and there was no response, and we realized the sky didn't fall, right? And they're not doing anything. They didn't exactly approve this, but they're not acting as though they disagree with our court's interpretation of it, that the letter of intent is just as good, So we're going along and thinking, yeah, Okay, this is good. This is good. Okay, so with that setup, um, I will go at this point to another uh, court case that was going on in 2006 as well. And this was sort of the most recent case in a series of cases that had gone on for close to 30 years by that time in both tribal court and federal court originally, but then after 1988 in tribal court as well. And these were a series of suits that had been brought against the Cherokee Nation by the group that are called the Freedmen, people who are descendants of the Freedmen. And these folks had been citizens, their ancestors had been citizens of the Cherokee Nation in the late 1800s. But they had attempted since the 1970s and the implementation of a new constitution, a superseding constitution, elections that had begun to be held again, a tribal council that had been reestablished again in the 1970s. From the 1970s, some of the Freedmen descendants had been sort of testing whether they were also going to be included in part of the sort of re-emerging Cherokee Nation of the late 20th century. And there had been some conflicting actions on the part of the registration department, on the part of the tribal council. But as the lawsuits began to get underway, every decision in the late 20th century, whether it was in the federal courts or in the tribal courts, had gone against the Freedmen. The decisions had said that the language of the 1975 Constitution had excluded the Freedmen from citizenship in the late 20th century. So there had probably been half a dozen different rulings in those 30 years or so, and every one of them had either said, well, the Cherokee Nation, well, basically what they said was the Cherokee Nation has the right to decide this for themselves, right? Those in the federal courts at least, and in the tribal courts, ultimately, they had said, well, the 75 Constitution excludes the Freedmen. But in 2006, the same three justices who had given the approval to go ahead and implement the 1999 Constitution, this question was in front of them in a case as well. And in 2006, the ruling that came from this court was that actually the 1975 Constitution was too ambiguous in its language to specifically exclude the Freedmen. There wasn't anything that specifically said the Freedmen was excluded. It was just sort of an assumption that had been made on the way that the language did exist in the 1975 Constitution. And so the decision in that 2006 case was not an order let me step back. It was not saying that the 75 Constitution said to include the Freedmen. It was not saying that the 99 Constitution said to include the Freedmen. What the ruling said was that the language was too ambiguous. And given more definitive language, that the Freedmen could not really be excluded, given the history of this nation. And so on the basis of that, the Freedmen began to be registered with the Cherokee Nation because that was the order of the court. But the court's ruling in 2006 also went on to say that if the Cherokee Nation wanted to, its right as a sovereign government was to develop clarifying language and place that in front of the voters to amend their constitution, to have language in it that was more clarifying, that was specific about the Freedmen. They didn't say how the language had to go, yes or no. They just said to clarify, whatever was the will of the people. And so, as you will recall, after that decision came down, there was a petition, a referendum effort to gather signatures on a petition to place an item in front of the Cherokee voters, clarifying language. The language was that one had to be Indian by blood, as well as descended from the Dawes-Rolls, right? That would be the criteria for citizenship going forward. And that petition gained enough signatures, and so in March of 2007, approximately 8 or 9 months later, you will recall that there was a special referendum, a special election, not an election, a referendum that year to put this question in front of the Cherokee voters to accept this clarifying language or not. And the vote was about 77% yes, to go ahead and put clarifying language in the 1999 document stating that one had to be Indian by blood, right, in order to be a citizen of the Cherokee Nation. And so once that happened, well, let me say there were about 2,800 freedmen who had registered as citizens of the Cherokee Nation between the 2006 ruling of the court and the 2007 vote by the people for a constitution. About 2,800. And these people had not been citizens prior to the 2006 court decision. That's one of the common misunderstandings in the way that this has been presented by the media and others. But in those 9 months, they became citizens, right? They were registered as citizens. Immediately, lawsuits were filed to challenge this vote on the part of the Cherokee people. And while this, since this ended up in federal court, and actually the freedmen filed in tribal court, and then a little bit later, the Cherokee Nation filed a different kind of suit with different strategy in state court, first of all, and then in federal court, trying to merge some different pending cases together just for more expeditious purposes. But anyway, after this had been filed in tribal court by the freedmen against the vote of the people, the Cherokee Nation stayed I guess what we would call the order disenrolling the descendants of freedmen, pending the decisions of the court. And so one of the other things that is commonly sort of misunderstood is that freedmen were being disenrolled. And actually those 2,800, there may have been sort of a moment, but effectively they have continued to be citizens of the Cherokee Nation for all of these 12 years since that time, and they are today as well. So anyway, just setting that up, I don't want to get into the weeds of the freedmen issue or the legal cases themselves. But the reason I'm going into all of this is because it became important as we moved towards 2007, 2008, 2009 into 2011 and the elections in the Cherokee Nation of that year. Let me go back and reiterate again that when we went ahead and implemented the 2006 Constitution without the Bureau having signed off on the amendment to remove themselves, they did nothing, right? And as time went by, they agreed, went along with all of the changes that we had made, changes to our legislative body, changes to our judicial branch. And so we went ahead and we started legislating. We started making rulings on court cases. We started or continued acting like a government, but doing so under the terms of the 1999 Constitution. The issue came up, however, these court cases that had been filed by the freedmen in 2007, they languished at the district level. We have 2 levels of court in the Cherokee Nation, and they went to a district court that was presided over by a judge named John Cripps. And after the arguments were made, literally years went by without a ruling from Justice Cripps. And after approximately probably 3.5 years, something like that, we were in the middle or at the outset of a tribal election at the beginning of 2011. And suddenly, after 3.5 years of this case languishing in the Cherokee courts, right, Judge Cripps issued a decision that said the freedmen must be incorporated now as citizens of the Cherokee Nation, and that the vote on the part of the Cherokee people in 2007 was unconstitutional, right? That it wasn't an appropriate vote. So, so this threw things into something of a turmoil in this election. And at this point, we begin to have sort of coercions and pressures of various kinds that begin to be applied by the Bureau of Indian Affairs in particular, on the basis, as they said, that the Cherokee Constitution of 1999 was not in effect at the point in 2007, 2006 and 2007, when the petition drive was underway, when the vote to amend the Constitution, the 1999 Constitution, took place in 2007, et cetera, et cetera. And the reason they said that that Constitution was not in effect was they said they had never signed off on it, right? On the one amendment that had removed them from the approval process. And so literally after 4 or 5 years now of the Cherokee Nation going ahead and making all of the changes, and the Bureau of Indian Affairs never saying a word about it in terms of the changes to the legislative branch, to the judiciary, suddenly popping up and saying, no, you can't do that because you can't have this vote, you can't collect signatures on the petition the way you did because, you know, we never signed off on it. Now, this is the Bureau saying this. This isn't necessarily the Secretary of the Interior saying this, but this is, you know, this was the justification for the coercion that begins to be applied at this point, right? I will just sort of step aside and say that ultimately the Bureau of Indian Affairs did sign, or the Secretary of the Interior, I should say, did sign off on this, but he signed off in 2009 rather than, you know, and the vote had been taken 2 years earlier. So, you know, the argument, the technical argument was that, that at the time when the vote was taken, the approval on the part of the Secretary of the Interior had not gone, it was not in place at that point, right? But the question that of course comes in for us at this point, well, if that was not in place because the Secretary had not signed off on it, then why was the Bureau and the Secretary just silent for literally 3 years while we went ahead and legislated, while we went ahead and heard court cases and our courts made decisions, et cetera, et cetera? Because the implication of this, we believed, was that if nothing that we had effected between or let's put it this way, if the vote in 2007 was not constitutionally permissible, then nothing that we had effected between 2006 and 2009 was implicitly permissible as well, right? So our question was, does that mean we've got 3 years worth of laws that we have to throw out, right? Is anything that the tribal council that now includes 2 at-large representatives on it, is anything that they did during those 3 years legitimate, right? The same questions for the court. And if they weren't, then why in the world has the Bureau of Indian Affairs allowed us to continue to do all of this and not stepped in and raised objection beforehand? Why is it suddenly and only now and only on this question of freedom citizenship is the Bureau, which mind you is not the federal court, right, but it's a federal agency. Why now are they stepping in and saying this is, you can't do this, right? we in fact did not have a decision from the federal court at that time. All we had was the decision from the tribal court judge that he had been sitting on for 3.5 years. Right? Our own Judicial Appeals Tribunal overruled, or our Supreme Court, I'm sorry, as it was being called by that time, overruled the district court judge. And you will recall that the flurry of legal action that went on in the summer of 2011 was just phenomenal. We had an extremely close election at that time, and we had to do a redo of the entire election. We had a decision from our Supreme Court that was just an in-your-face to the federal court sort of decision that said, nope, we're going ahead and ordering the disenrollment process, et cetera. Our Attorney General at that time sided with the federal court and said, you can't do this. You know, there is a plenary, there is a higher level we have to do what the federal courts do. Our tribal courts do not trump them, right? And so it was just a really contentious and really amazing time. But what happened as a result is that because of acquiescence to some things in the federal courts, even though ultimately we won in the federal courts, but we had already acquiesced and made some deals. And part of that was that whole episode in the summer of that year was that the freedmen descendants would be allowed to have an additional 2 weeks of time to vote, right, because they've been prohibited from doing so previously. So again, we kind of have to set up the issue to understand the constitutional question. I'm not going to go any more into the weeds, as I said, of the court cases about the freedmen. But one of the things that we have grappled with since then, and which has been used, I think, by the federal agency that is the Bureau of Indian Affairs in particular, to sort of apply coercion to the Cherokee Nation, has been the fact of this action of going ahead and implementing this 99 Constitution without getting, strictly speaking, the approval of the Bureau or of the Secretary of the Interior on this. Okay. I'm looking at the chat, and I will echo this, that if people do have questions, because I think my experience and that of everyone is when we get into talking about legal matters in particular, things can become very, very convoluted, and it's hard to sort of do things with some broad brushstrokes here and make it clear. So if there are confusions or if people have questions, please do present them. There are two other things that I wanted to speak to tonight as well. They won't take nearly as much time as this has because they're not as long standing, they're not as sort of complex as this issue of the freedmen vote or the vote on freedmen citizenship and the approval of the 99 Constitution. But one of the things that happens in the 1999 Constitution, as many of you know, is that we have at-large tribal council representatives for the very first time in our nation's history. And as part of the discussion of the 1999 Constitutional Convention, the addition of these two tribal council members was a really significant part of that convention. The discussion went on for something like 8 or 9 hours. It went on one evening, and then we had to recess, and then we picked it up the next morning and went for, the better part of the next day, probably, in the same discussion about how to word the articles that would deal, or the sections of the article that would deal with the new at-large representatives. And what was ultimately done out of the Constitutional Convention was to leave this particular, or these particular representatives free of the requirement that they had to reside within the district that they represented. For all of the other counselors, the 15 tribal counselors who represent the people inside the Cherokee Nation's jurisdictional boundary, they have to reside, each of them has to reside within the district that they represent. But the thinking was that on the average representatives, it's really not a district, it's sort of all the rest of the world, you know? And we're going to have two people that are covering a population that is so much larger than the individual 15 members within the boundary represent. They're going to have to do it in tandem because it's just unrealistic to think that a single person could take even a portion of that and represent it very effectively. And the thinking was that because there is so much other business of the Cherokee Nation that goes on right there in Tahlequah or in Catoosa, you know, where the business board meets, and that while somebody could come from outside the boundary and come to Tahlequah for council meetings, because there's just so much else that goes on as well in between those council meetings, it really could be very beneficial to the at-large people if their representative, you know, was also right here in the district or nearby and could participate in many of these other kinds of meetings and activities that take place as well. And so the thinking was that, you know, if you're representing a district within the boundaries of the Cherokee Nation, one of the reasons to say that you reside there is because you will reside near most of your constituents. But if you are an at-large representative, it doesn't matter where you live, you're never going to reside near most of your constituents. Most of your constituents inevitably are going to be somewhere else other than when you reside. So this was the second rationale, was just that, you know, the reason for doing this in the case of the 15 in-district councils, just there's no way it's ever going to apply for the at-large representatives. So it just doesn't make sense to place that restriction on the at-large representatives. So very deliberately, the body at the Constitutional Convention had not said anything on this question. They had left it wide open. And so that's how it was implemented. And in 2007, which was the first election for the at-large representatives, my legal residence was in Tahlequah, Oklahoma. I had a second home in California, but my legal residence was in Tahlequah, Oklahoma. And our election commission accepted all of my documents, my driver's license, my voter registration, my tax return stating that I was a resident of Oklahoma, et cetera, and nobody questioned that at all, because at that moment, it was entirely permissible to reside within the boundaries of the Cherokee Nation and run for the at-large seat. 4 years later, in 2011, it was exactly the same thing, right? All of my documents that I brought to file for candidacy said that I was a legal resident of Tahlequah, Oklahoma. And once again, that was just fine. And I went ahead and ran for the at-large tribal council representative. But 2 years after that, in 2013, the tribal council at that time decided that they would pass legislation that did place a residency requirement for candidates who wanted to run for the at-large seat, right, to be the at-large. And they said at that time that you had to live outside of the Cherokee Nation jurisdictional boundary now in order to run for that seat. And lawsuit was brought into the Cherokee tribal courts at that time that said that the argument that was made, the central argument of that case, was that the tenet of law is that legislative bodies cannot pass legislation that is more restrictive than what is in a constitution, right? And that's what this body had just done. And the court in 2013, it was a split decision on it, but the majority ruled that they ruled against that argument, and they upheld the law that had been passed, right? So here we have an argument. You know, it was ultimately not accepted, but the argument was that there was when the Constitutional Convention left this deliberately broad, there was a reason that they did so, and it was not incorrect. It was incorrect to come back and do something different than what the will of that Constitutional Convention had been. But the court did not agree with that. I see a question on the chat. Can this ever be overturned? This was the Supreme Court that made this ruling. So, you know, the court generally rules on the constitutionality of questions. It could be rescinded by the tribal council, you know, later on. That could happen. We could have a constitutional amendment that would specifically say, you know, that isn't left ambiguous again. I presume we could do something like that, you know. So there are ways that this could be changed, I think, but I'm not sure that it could ever be overturned through our court, right? If there was a different kind of argument that an attorney could come up with, maybe it could be challenged on the basis of that in a different argument. But I think it might be more worthwhile to do this through the legislative process with a more favorable legislature, a more favorable council. The last thing I want to talk about this evening, I'm glancing up to look at my clock because we don't want this to run over as so many of the others have in the past. The last thing I would like to talk about is that we have had a recent ruling from our current Attorney General, and that because of the things that happened in 2011, that the present chief, Chief Baker, was not able to take office that year until 2 months after the term should have begun. This was because we had to completely redo the election in 2011 because of the closeness of the vote, and also because of decisions that were coming down out of the tribal courts and the federal courts involving the freedmen. Chief Baker should have taken office on August 14th of 2011. He was not able to take office until October of that year. And so the question that was asked of the Attorney General was that, in his opinion, could Chief Baker run for a third term because he had not been able to serve a full first term. It had been shortened by 2 months because of this. And the Attorney General ruled that an interpretation of the Constitution was that Chief Baker had not served 2 terms, and therefore he was not term limited out and could run again for a full term, a second full term. There is a citizen of the Cherokee Nation, David Cornsilk, who has asked the Cherokee Nation courts to overturn the Attorney General's decision on this. And just a couple of weeks ago, there was a decision from the lower court in the Cherokee Nation that upheld the Attorney General's decision. And this, I believe, has been, well, I think that Mr. Cornsilk has stated that he intends to appeal this. I don't think it's happened yet, but it would be reasonable to assume that it will be. Now, the reason I bring this up is because this is, I guess, something of a constitutional question, because term is the terminology that is used in the Constitution. But because this has happened, this might be a question that could be debated, that would come up for debate at a future constitutional convention. Our Constitution, our present Constitution, says that we have to have a convention every 20 years. That would put it at 2019. Some people think it would put it at 2023, since our Constitution was not actually voted on, approved by the voters until that year. But whether it's 2019 or 2023, or maybe even before that, if the constitutional amendment wanted to be voted. One of the things is that we never find out what we haven't addressed. We never know what the weaknesses are until something happens, right, that we haven't thought of, that we haven't included. And so this may be the kind of question that could be debated at the next constitutional convention. What is the definition of a term? When we have implemented term limits, is it reasonable that somebody gets an additional 4 years because their first term was shortened by 2 months? You know, you know, what are the parameters that we are going to think about there? You know, in terms of how long is the term shortened? Should it be shortened by before we give somebody an additional 4 years, and think that's reasonable? So I think that's about all I have to touch on at this point. And I'm not seeing additional questions, but please type furiously now if you do have some.
Okay, well, I guess that's it, Julia.
Yep. Thank you, everyone, for being here tonight.
Thank you for joining us tonight. This concludes our series on the Cherokee Constitution. If you have suggestions for future webinars, we'd love to hear from you. We hope you will join us for our next webinar on Native American home loans, which will be hosted by Brandon Caruso from the Tulsa Cherokee Community Organization and Today Lending. Special thank you to Dr. Julia Coates. This webinar has been recorded and will be available on the Cherokee Pens YouTube channel. To learn more about Cherokee Pens Project Foundation or get involved, please contact us at www.cherokeepens.org or email us at cherokeepens@gmail.com. Good night. Donegal, go Hawaii.